Hi, everyone, and welcome back to our Workers' Comp webinar series. In part 4 of our journey through the California's workers' compensation landscape, we'll tackle critical topics such as returning to work with modified duties, strategies for disputing denials and appealing decisions, understanding the pivotal role of attorneys in the process, and addressing the serious consequences of fraud. With so much ground to cover, let's just jump right into these essential discussions. Speaking about returning to work, which is our next slide for this webinar, what is the importance of returning to work in the sense of your earnings, your job offerings? This is something we talked about in this vocational rehabilitation as well. But what does modified work and new job opportunities look like when you go back to work? Give us the scenario of some of the things you've seen in the system and injured cases you've taken on.
Sure. So I think return to work can mean different things to different people. You can have someone who is offered full-time permanent work that maybe has some restrictions, but it was their usual and customary work. It was what they were doing before, but just maybe some tweaks.
Right.
Then those other people get offered permanent modified work and it's significantly less pay, or it's in a different location. Or maybe it's just doing something completely different, and those things are all okay, right? It's not necessarily discrimination just because they go back to work in a different capacity. Sometimes that's the only way they can go back, and maybe
Right.
it's in complete good faith. And so if they have modified work for you and you choose not to accept it, and that modified work is within your work restrictions, technically the employer can say, okay, we're going to go ahead and let you go then. So the employer only has to actually make a good faith effort. Of course, they can't make up things. They can't single you out and choose you specifically and say, well, you know what? Sally got injured. Sally has the same work restrictions, the same injury, everything, but we're going to offer her a job that pays 60% less and it's night shift only. But Bob got injured and has the same exact injuries and all that stuff, but we're going to offer Bob the day shift and we're going to pay him 100% of what he was earning before, and it's like the same modifications, right? That would be some example of discrimination based on their disability and work restrictions and such. But people may choose not to accept their offer of modified work. They may say, you know what, my doctor says these are my work restrictions, but I really can't do it.
Yeah.
But it's the doctor's work restrictions that really control. So sometimes people are put in a tough spot where maybe the work restrictions aren't necessarily matching up to what they know in their heart, they feel. And they have a tough choice to say, okay, well, if I don't accept this, I could lose my job. If I do accept it, I'm going to put myself at risk for further injury. And so in those circumstances, we always tell clients, go try and negotiate with your doctor, ask them to change your work restrictions. If you need it more restrictive, explain why and be upfront with them. And even if they're asking you to do stuff that's a little, maybe, it's pushing your pain threshold a little bit or tolerance, at least go try it, and give it a good effort, try not to lose your job over it, and then go back to your doctor and try and tell them, hey, I went back, I had this bad experience. These are the things that were causing me problems. And I'd really appreciate it if you, made my work restrictions X, Y, and Z.
It's good to know that there's rights and what are some of the obligations an injured worker has when returning to work? Do you have to notify? How does that fall into place?
So it depends on whether you're talking about returning to work when you've been temporarily disabled or when you've reached maximum medical improvement. When you're talking about being temporarily disabled, you should always be giving your work status to your employer. So you're going to go to your treating physician every 45 days or so, and they're going to give you something called a work status form. And you need to take that work status form and turn it into your employer, and it keeps them up to date on what your work restrictions are. So you're always wanting to maintain communication with your employer about what's going on with you.
Don't ghost that employer, because then they're going to just assume that you're no longer interested, and it's just all bad from there.
Yeah, and sometimes they can accommodate, sometimes they can't. I think the vast majority of people want to go back to work, and so they'd be happy if their employer said, you know what, come on back and we can work with you. We can make sure you're not doing things that'll cause injury. But if your employer says, hey, we can accommodate, and you don't report back to work, you can actually lose your job.
Okay.
So, it's incredibly important that you maintain contact with the employer, especially when it comes time to return to work.
Now, you can dispute the resolution of you returning to work. You mentioned this earlier. If you feel that you're just not there yet, what does this dispute look like?
So your treating physician can talk about work restrictions. Your QME can talk about work restrictions, or if you have a lawyer, an agreed medical evaluator. Um, but sometimes the work restrictions aren't the same depending on the doctor, and so you have to slug it out and determine which doctor you're going to rely on, and which doctor has a better report and stuff. But as far as the work restrictions are concerned, it's something that's brought up a lot.
Mm-hmm.
There's sometimes where injured workers are given work restrictions that they don't want. They want to be released to full duty.
Yeah.
Or, maybe the doctor, whether it's the QME or the treating physician, gave them restrictions that were, not enough. And so they want more restrictions, right? And it goes both ways. And I think it's a bit of a dance that you have to do with the doctor to articulate why it is you want what you want.
Mm-hmm.
I will say this, there are a lot of doctors that are sympathetic to people and they don't want them to lose their job. They're not trying to, give them work restrictions so they're forced out of their employment. And I would say probably more often than not, at least when it comes to reducing work restrictions to let people go back to work, I'd say doctors usually accommodate that. They'll
Nice.
usually say, hey, look, you want to try to go back with the least work restrictions possible? I'll let you try that.
Right.
And then come back to me if you're having problems and we can, then we can readdress it.
Yeah.
I think it's harder to go ask for more work restrictions.
Yeah, I can see that. It's not going to happen. You were talking earlier a lot, and you gave a lot of examples that have to do with firefighters, and it just there is a very important subject within the California workers' compensation system that I think we have not touched yet, and that is getting denied, getting your case denied, and having that door shut on your face and saying you're not going to get help. What does that look like for an injured worker? Because it happens.
A lot. So I can start by going back to the claims process, right? We talked about earlier how when you're injured, you make sure you report that claim to your employer. You fill out that DWC-1 claim form. If you can't get that, just make sure you scream from the rooftop so everyone knows you're injured. Send texts, emails, make phone calls, document, right? Once your claim gets reported to the insurance company, the insurance company opens up their case. An adjuster will usually reach out to you. You'll get your first doctor's report. The insurance company has 90 days to investigate your case. And that 90 days is spent determining should we accept liability or should we deny liability.
Mm-hmm.
So sometimes the insurance company will accept the claim right away. It's clear.
Yeah.
You sawed your leg off on the job.
Of course.
10 people were there watching it. They took you to the hospital. It's like clear as day, Other times, maybe it's not so much. Maybe there was no one that witnessed it. And so
scary.
Yeah, maybe they say, well, we don't know that we believe this guy. We talked to him on the phone. We interviewed him. He sounds sketchy. We think we need to do a little more research, talk to the employer and such. If the insurance company does not want to accept it right away, they issue what's called a delay notice. And this is a notice you would get in the mail, just like you would a notice accepting liability for your case. The difference between getting a delay notice and an acceptance notice is that during the delay period, while they're investigating, they do not have to pay you temporary disability benefits. So if you're off of work because of your injury and work restrictions, they're not going to pay you those benefits during that time. They will provide up to $10,000 in medical treatment, but no temporary disability.
So you wouldn't be getting paid your check, and you would have to use personal time off, sick days, as much as you can to kind of pay the bills. People still have bills to pay.
Yep. And, tip and trick, if you're in California or an employee, check your pay stubs. There's a line item for something called CASDI, which is California State Disability Insurance. And if your case is on delay or denied, which we'll get to, you can always apply for state disability as a gap stop, assuming you don't have sick time or vacation time accrued. So they'll cover in between. But once the case is accepted, if you were off of work because of work restrictions from the work comp doctor, then they will go back and pay you that retro temporary disability benefit to make up for it and then pay benefits going forward. But they could go the complete opposite way, which is a denial.
Yikes. Okay.
And so within that 90 days, if they choose to deny your case, they will cut off your medical treatment. They won't pay you any benefits and you're on your own.
What rights do you have if you know you legitimately got injured at work and you do need medical treatment and you're getting cut off? What are your rights? What do you do?
Well, you should litigate the case. You'd file a workers' comp case at the Work Comp Appeals Board, which is our court system for workers' comp. And you essentially appeal the denial. And there could be a number of reasons why your case is denied. It could be medically, because the doctor said they didn't think you were hurt at work. It could be factually, meaning the insurance company thinks you lied about how your injury took place. Maybe they think you actually got hurt snowboarding on the weekend, not, falling off a roof or something. Or, there could be a legal reason, meaning, you were drunk on the job and only fell off the roof because you stumbled because you're drunk, right? Or
Right.
you got hurt because you picked a fight with someone bigger than you and they whooped your butt. And, workers' comp doesn't cover
Right.
initial aggressor injuries. So, there could be a variety of reasons why your case is denied, and you get to appeal that at the Workers' Comp Appeals Board.
Interesting. So you have rights. There's options for you to do that. How long does this approval of a denied case take?
So it can take a long time, it can take a long time depending on what it is. But to file a case at the Work Comp Appeals Board, you need to file it within 1 year from your date of injury. Or if it was accepted, it's from the last date of the last benefit conferred. But if you're talking about strictly a denial, you get 1 year.
Okay, so that's good to know. There's important dates that you need to take into consideration if your case has been denied. And you need to appeal. That's the only way to kind of reverse that. Is there anything else that we need to talk about as far as like denials?
Yeah, when you're talking about denials, it can be as easy as having to go against a doctor because it was just their opinion. They didn't think you were hurt at work, but it's easy to find a doctor that has a different opinion.
Mm-hmm.
When you're talking about a legal denial, of like a factual denial, things like that, you're talking about a trial. Like just automatically, that's going to be a trial,
Yikes.
which means you need to gather evidence. You usually need to subpoena documents. You may need to take depositions. You have to subpoena witnesses. You do the lawyer stuff.
You have to
and
put in
so,
the work.
Yeah, so it's not an easy process. It's not something you can just kind of navigate on your own, I think.
Okay, that is good to know. Moving on to our next topic. So obviously there's a lot of information given throughout this webinar that is entitled to the California Workers' Compensation System. One question that I did have for you, however, is most of this information we're given is to the general public, general workers, for example, delivery drivers, construction workers. Are there any job sectors within the California Workers' Compensation that do have different challenges or different benefits that we don't know about?
Yeah, so there's quite a few actually. There are teachers, there's some medical professionals for COVID and things like that. And there's also first responders. A lot of them have their own dedicated rules regarding presumptive injuries. So, for example, police officers who've been wearing a gun belt for more than 5 years are entitled to a presumptive low back injury, which means when they file a case alleging that their back was injured as a result of their employment, it's presumed that it happened at work. Same thing for types of cancers, as well as heart troubles, things like cardiovascular disease, heart attacks, hypertensive disorder. All those things can be presumed to have been caused by work if you're a police officer or a firefighter.
Interesting. Are there any unique challenges for the first responders and firefighters?
Yeah, for first responders, it's very difficult because they have tough jobs. When you're a police officer and you're having to chase after people and wrangle people and do a lot of really physical, intense stuff. Even the most minor work restrictions can be pretty significant and affect your career. And same thing for firefighters. You have firefighters who are out there who are, having to do pretty extreme work as well. And certain functional limitations can really hamper their ability to continue on with their work, even if they're not ready to necessarily leave yet. So when we handle fire cases and police officer cases, we take a great deal in care in working with the doctors on things like work restrictions, and also if they're applying for things like CalPERS disability retirement, making sure that they're going in the right direction for that as well. There's also some benefits, in terms of the financial benefits. Police officers and firefighters are entitled to, we call it 4850 pay. That's the section of the labor code that states that for their first year off of work, instead of getting temporary disability, which is 2/3 of their average weekly wage, they get their full salary.
Oh, so nice.
Yeah, so it's better, it's more money in their pocket, basically. And then after their first year of being on salary continuation, then they transition to temporary disability for the following year. But yeah, there's a lot of unique challenges for firefighters and police officers, first responders in general, because most of them love their job. Most of them aren't
Yeah.
ready to leave yet. And unfortunately, injuries happen. And it's how do we navigate the system and, get them the most medical care, the most benefits possible, but also get them back to work to make sure they can continue on with their career.
What does this look like for them in as far as like navigating specialty or specialized benefits for them? Is it harder to get certain things or is it easier?
Well, the presumptions, for example, if you're in the industry and you know the presumptions, it's easy to speak to clients with confidence to say, hey, look, if you file back injury because you're caught for 15 years and you're sitting in your patrol car with your gun belt on and, having to have 15 pounds on your hips and stuff,
Yeah.
it's a lot of weight. And so it's easy to know the rules and speak with confidence to say, hey, if you file this case, it will get accepted
Yeah.
versus not knowing, in the first place, or, maybe you aren't receiving salary continuation at the right pay rate, or maybe, you need help navigating how to apply for a disability retirement with your city or your municipality, wherever it is, or, CalPERS. There's also the component to it of like how to just navigate the system in general,
Yeah.
how to match what their goals are to what their options are and how to navigate that.
Yeah.
It's incredibly important.
That's a lot of information. We delved into the overview of the legal rights you have as an injured worker here in California. What is the role of an attorney? We understand everything that could potentially go wrong and all of your benefits you're entitled to, but where does an attorney come into play and why?
We're your counselor, we're your confidant. We're here to essentially explain things to you, give you your options, and guide you through the process. We're not your decision maker, though. As an attorney, our job is to educate you and basically help you understand where you are on the map,
Mm-hmm.
so you don't get mixed up. There's some strategic decisions that lawyers make on behalf of the injured worker. QME selection process, for example, is a huge one. But generally, we're here to walk you through the entire process from start to finish. And if there's areas where there's a lot of friction and we need to fight, we fight.
What does a fraud and the consequences that go along with fraud look like for someone that wants to cheat the system?
So it doesn't come up a lot, but fraud is out there. There's people who say they were injured at work and they weren't, or there's people that um, are telling their doctor they can't work because of their work injury, but then they're caught working, on
On the
camera.
side.
Yeah. So there's something called Sabrosa investigators in workers' comp that literally means under the rose. It was a Latin term relating back to Cupid. And basically has nothing to do with love anymore. But
So
it's
you're
all
telling
about,
me Valentine's is not what it meant?
no. But basically, there's these investigators. There's the kinds of guy that like hide in the bushes out front of your house and follow you around. Their sole job is to catch you doing things that you shouldn't be doing in hopes that they can somehow use that against you in your workers' comp case. And sometimes it's just insofar as like, hey, look, this person looks pretty good. Doctor, don't you think they're not as bad as you said they were?
Yeah.
Other times it's like, this person lied, straight up said they weren't working or that they couldn't do X, Y, and Z, and they're clearly doing it to the max here.
Right.
There was one firefighter, I think he was Los Angeles County firefighter, and he got caught, I think, doing scuba diving lessons or something like that after he had received a pretty significant workers' comp award. And so they're like, whoa, this is fraud. This is fake. This guy's fine, and like he got some big award from his work comp case. And so you can actually be prosecuted for fraud by the district attorney if they want to take up your case. Sometimes if you're caught, engaging in fraudulent conduct, you can kind of make it go away. You can settle the case.
Right.
Defense attorney won't report it, or the insurance company won't report it for fraud prosecution and things like that. It just depends. But there are pretty significant consequences, including prison time.
Okay, that's good to know. And it doesn't just happen for the injured worker. I'm assuming the same goes for an employer that is essentially doing workers' comp fraud, trying not to, have the injured worker say that the claim actually happened at work and it happened at home. There are some consequences for them as well.
Yeah, I mean, every party can get caught doing stuff they're not supposed to, and there can be significant consequences. There was a physician in Southern California some time ago who was getting paid, I think it was like $6 million in kickbacks for referring patients to a specific hospital for spine surgeries. And if I'm not mistaken, he's in prison right now.
Yikes.
So, And then same thing goes for the insurance companies. They can get caught engaging in fraudulent conduct too, and there can be consequences for them as well.
I'm glad you talked about the insurance company. That was my next one. I get it, the employers, employees. What about the insurance company when they commit fraud? So it's good to know that there is legal rights and responsibilities for each one of the parties involved. When it comes to the California workers' compensation system, let's recap the key points of this webinar, the importance of making sure you submit that DWC-1 claim form, informing someone of that injury, knowing the difference between permanent disability and temporary disability, the factors that come into play from someone getting benefits for the workers' comp system, which essentially is medical and some sort of compensation while you're off of work. But the most important part is the medical treatment that comes behind it, and the power of being able to jump into a different rehabilitation, vocational rehabilitation, so that you can essentially restart if you need to. There are rights. I'm just thankful that we have Bilal that shares this information on the website for us. It's so accessible now. It's free. There's no need to pay for a consultation from a workers' compensation attorney. If they are charging you, run fast. What's another form of, contact we can give anyone watching this webinar right now that they can dive into and kind of learn a little bit about the system itself? What are websites they can visit?
Check out Pacific Workers for one. We've got a fantastic blog. You can also check out our YouTube as well. We've got a lot of content. And we also have a separate podcast called Work Comp Talk, where we dive into a lot of issues and talk about specific circumstances and things that pop up in workers' compensation cases. You can also check out the state DWC website, DRL website. It's the Workers' Comp Appeals Board page. They have an information and assistance section. They also have forums and things like that on there. And if you just simply Google some stuff, there's a lot of information out there, and, whether or not you're injured, I highly recommend you check it out. Because again, you don't want to be learning this stuff on the fly when you're in the middle of it. It's easier to be ready and be educated ahead of time.
That would definitely suck. And as you mentioned earlier, Bilal, we do have a podcast with it. A lot of this information, we'd love to sit here and dive directly to it. It would take hours and hours of discussions. However, we are going to be linking a lot of the conversations and podcast episodes to some of this information, and you'll find all of that in this webinar and descriptions as well. So if there's something in particular you want to learn more about, whether that's, temporary disability benefits, we will be linking some of those episodes for you as well. And you can check out the YouTube channels. All of the information will be linked throughout the descriptions. We are thankful that you made it through this entire webinar. It's a little bit long, but definitely well worth the wait to learn all of this information. And this is just the tip of the iceberg. There's so much more you can dive into. So thank you, Bilal, for your time. And I hope we get to do this again. And I hope you guys learned something from this. And we'll hope to be able to have helped someone in some way, shape, or form. Thank you.